Hello, Uganda. Good evening and welcome to the show On the Spot. My name is Patrick Kamara. Tonight, the President Yoweri Museveni has applauded Parliament for its legislation this week on the two bills, UPDF Amendment Bill and the Political Parties Bill. The President went ahead to call out the opposition MPs to apologize to Ugandans for trying to fence out such an important legislation. The UPDF Amendment Bill that is so contentious is said to have about 89 articles amended, which are very much perplexing to Ugandans. We will try to make sense of the bill and all what transpired from the proceedings. Let me introduce my panel this evening. I have the Honorable Medad Segona, Member of Parliament for Busiro County East. Thank you so much for joining us. Good evening, sir.
Good evening to you and good evening our viewers.
I have Honorable Eddie Kwizera Wagahungu, Member of Parliament for Bukimbiri County. Thank you for joining us.
Thank you, Andy. Good evening to listeners.
So let me begin with you, Honorable Medad Segona. Members, your colleagues and others moved out yesterday, but still the bill was passed. And yet some people thought you could have stayed in, give your reasons, debate against it, and it is recorded on the Hansard that this is what Honorable Medad Segona said and the colleagues. And if, posterity is to judge you good, it will, because whatever you would have said and the disagreements would have been captured on the Hansard, but that was never the case.
Yes, there's no arithmetical answer to decisions of this nature. Some people, yes, would feel that we should have stayed in, and others felt that we were right to walk out. Whichever way you look at it, I think we took a decision that was taken by the majority to walk out, and I think the most salient reason that was given was that people were not feeling safe having a discussion with the usual tortfeasors surrounding them outside the chamber of Parliament. Yes, we walked out. Does it make the law good? Does it look our colleagues who passed it look good? Does it translate into something brought in good faith? I can only answer those in the negative.
So, Honorable Segona, you really thought that if you stood your ground and stayed on the floor of Parliament, some people would storm it and perhaps things would have turned chaotic?
It has become very unpredictable. If you have a CDF who picks somebody from his house and takes him to the basement, what is not possible with his juniors? If you have a CDF who tells his former commander, former deputy CDF, that he's a buffoon, he should use his small legs to run very fast before he captures him, to kill him. What would not happen with his junior officers who have inflicted pain, maimed and broken limbs before in the same chamber?
The same CDF, if you are saying in that manner, he can actually even find you in Busiro or find you here, but you still do your work.
Yes.
So how come you have not exited Busiro, you're not exiting Sere?
I do not sit in harm's way and wait. The best would be, let me leave him or leave his space. If he wants to come to Busiro, he's welcome. So
you are actually saying, as a member of Parliament, an honorable member of Parliament, that you are living a life of people who are so intimidated because of what you read on X?
I'm not intimidated, but I'm not.
But does it look like an intimidation?
But I'm not reckless. You understand? I am not intimidated. Look at me, but I'm not reckless.
Honorable Kwizera, this bill, we are assuming the president is going to assent to it and, of course, turn into law. Largely, most of the...
For your information, I participated in the committee proceedings. We were making good progress until that man interfered, when he called them to caucus and the things turned around. So I did not see a future in our participation. I had written with my colleagues a very good minority report, which probably would have educated them. Indeed, it was presented to them. What contribution did it make to their ears?
But Honorable Kuzera, now that you're talking about the caucus, the people who elected you in Parliament are the people who Bukimiri. Your real bosses are the people who Bukimiri. I mean, you have no business with the caucus. It's not the caucus that elected you in Parliament. Are you people going to listen to the voters at one point? Because it looks like in most cases the voters has been disregarded. Yet very soon you're going back to them to ask them to hire you again.
Well, Mr. Kamara, is that Israel here is not a spokesman of the caucus, neither for NRM. I carry the original voice of the people who elected me. And like Honorable Segon has said, every member of Parliament must have an opinion on whatever comes on the House. Where I partly don't agree with him is that where do you take that opinion? Do you take it out? Can you be heard if you are out? So I think that when you are elected member of Parliament, it is better to go to Parliament and air out your views, the views of your people who sent you, whether they agree with government, whether they don't agree with government. So when you come to the caucus, different parties have the caucuses, but whether it is opposition, whether it is NRM, they have caucus. They caucus. They build opinion. They build the position, and those positions which are built, some of them meet expectations of the people, others don't. Because even for the opposition to move out, it was a position that was not taken within the House. It was a position taken outside the House. So when our colleagues come in the House, they have their leader, their position is taken, and they go out. And that's their right. But when you come back to NRM, NRM has its own way of whipping and building positions on a matter. But most of the Ugandans, the problem we have is that they think that business starts from the caucus. This bill starts from the sector, well, in this case for UPDF defense. So when the bill comes, those people think that they can manage better when those kind of legislations are in place. But remember that we have different checks that must go through. So when the sector brings it and it goes to cabinet, cabinet must have capacity. I'm talking about capacity to check the provisions of that law that's being made. So as far as the cabinet has capacity, I cannot comment on that because I'm not a member of cabinet. So when that bill comes to Parliament, Parliament must treat it. It must treat it thoroughly. You know, Honorable Segona is a university teacher, although he's a member of Parliament. So Parliament must perform its work in accordance to the Constitution. Article 90. Every business that comes to the House must be processed in a committee of Parliament. Because not every member of Parliament can go to debate, and not all of them have the same skills and professionalism.
Most of the work is done at the committee level.
Yes, most of the work is refined, is treated at the committee level, in the committee, in accordance to the Constitution, Article 90. So when the committee where Honorable Segona is and they disagree, there is a provision for minorities, and at a time or two, you find the minorities actually even being more adopted than the majority report. So me, I think even if Honorable Segona had stayed, he would have urged to support the minority and the minority maybe would have carried.
I want to carry it from there because I think Honorable Kwizera makes a point. If somebody was there to read the minority report, really, you would have been...
Honorable Duru was there to read the report.
To read the report.
But he would look behind
to support
because there was a free sitting.
So what was the point?
Honorable Duru would be actually
supported and
supported by
people would have added on the
people
argument.
would have supported Honorable Duru reading the minority report, which actually had some good input. So, but because it was the runner.
So Honorable Segona, you were saying yes, you had some good views in the minority report, and actually in your submission you're like, but could they listen?
Not some good views. Actually, it was entirely good.
Yeah, if it was entirely good, and somebody was reading it to making sense for himself without you being around.
He prepared the good food and feared to serve the food.
I have told you, Kamala, because you see, the people you wanted me to serve the food are not organized people. I was going to say they are from somewhere in Luzira. They are not organized people. Instead of eating, they prefer spilling the food and pouring it all over. When we were in the committee, we were progressing well, like I did say. By the way, we processed so many provisions in that bill by consensus, especially those that relate to the welfare of our soldiers and ex-servicemen. To the extent that I am actually the one who brought in the provision to give the Act a retrospective effect, to help those who are already languishing in poverty, those that are already sick and are helpless, and so on and so forth. We were doing well. The only trouble was with respect to these two clauses, which we feel very strongly are unconstitutional and were the reason for this bill being brought. I mean, those issues of pension have been there. They've been subsisting. They've been looking after those people in Museveni, the maimed and so on and so forth. Why didn't they bring the bill before? But I think the major precipitant that caused them to bring the bill now were these two clauses that related to trial, especially of civilians in the military courts, or generally criminal trials in the military courts or establishments, which they think are judicial outfits, and basically the usurpation of judicial power. But that said, yes, do you mean that these people are not intelligent enough to have understood the contents of my minority report, even in my absence? No, it's just bad faith. Because even those things that we had agreed on when they went to Entebbe, their chairman told them, we are passing it as is. So forget about any concessions that you could
So let me ask, when a minority report is presented on the floor of the House, there's no debate about it?
There is ordinarily.
So how were you expecting for that debate to happen when your minority report is being read in your absence?
Ordinarily, it is supposed to be debated,
first, yes. And
you are supposed to dispose it of first. But the environment was not about that, because caucus had already taken a decision. Originally, Honorable Amson Obua said that this matter was not part of the discussion they were going for. After the meeting, he came out and said, we have taken a decision, we are passing it as is, no addition, no subtraction. So there is nothing that you're going to talk about. There is nothing like a meaningful debate and outcome arising out of that debate. No. So
on that Tuesday evening, I think it was Tuesday, when the bill was passed, Honorable Kwizera, do you think that added on Uganda's journey to democracy? Is that how democracy should really be exercised?
You say you can say like either party taking a position before they come to Parliament to debate. It means the decisions were taken, could have been taken before even the floor. So, you know, there is a political heat now in the whole country. And when there is a political heat, the temperatures can go up, and the reasoning also will be affected. Either way. So when you are conducting this kind of business, you don't look at the individual interests or sector interests. You look at the bigger picture of the country, because Uganda is like, when you talk of a global village, now some different countries or different parties, international organizations, will be looking at what kind of legislations we are making. And that one has a relationship with the flow of foreign investment. And also can have a relationship with our diplomatic relations. Because when they are providing when they are providing what we call country profile, they look at different things: the legislation, the politics, the legislature, the journalism. They look at the many things. So when Honorable Segona says that ideally close to 89 clauses of the bureau sections, and he entirely agrees that more than 80% of the bill is acceptable. So the originators of the bill wanted it 100% passed, but that is impossible. Secondly, when it comes to Parliament, Honorable Segona says about 2-3 clauses did not pass the test of Parliament because they must be a legislative test. So if that legislative test is not complied with, then there will be a judicial test, where I think some people could be going. So we should agree that there is, from sector, there is a test in cabinet, executive test. Executive test, when they produce the bill to Parliament, there is a legislative test. And if it goes without listening to some other views, it goes for judicial test. So it is a process. So we should now build confidence in our systems.
Has it not jumped the stage of going through a legislative test?
You know, now where we are, the legislative test, you ask, what was the score on the test? Qualitative and quantitative. Because to me, you find that quantitative, Segona will agree with me, that it was okay. Because you have the number. Qualitative, because of the 2-3 provisions we are talking about, the qualitative affects the quantitative. That's what needs to be tested by other people, because there is a division of what there is.
Let's dig deep in the qualitative.
Yes.
The 3 or 2 maybe clauses that maybe are causing headache. What's your fear, Honorable Segona?
Well, first, the biggest fear is not even whether it's right or not to allow the military exercise judicial power. You know, most people talk about trying civilians in the military courts or courts martial, but that's not the bigger picture. Now we have gone past that. The biggest problem now is the death of constitutionalism, because whatever the number, even if we had agreed unanimously, both sides of the aisle, and said that yes, we are passing this law, it would not meet the judicial or the constitutional test. Why? Because Article 92 bars Parliament from undertaking any legislation that has the effect of overturning a decision of court. We are not allowed. The Supreme Court pronounced itself. Actually, it's not even the Supreme Court. First it was the Constitutional Court. Then it was the Supreme Court which pronounced itself and said, 1, the trial of civilians in military courts should be only undertaken in the clearest of cases, actually, in very special circumstances. And the Chief Justice who wrote the lead judgment with which the rest agreed stated that only in situations where people are not in Uganda, or in situations where Ugandan civil courts are not functional. In other words, for example, you accompany the UPDF to Somalia, there are no Ugandan courts in Somalia which are functional, and you may not be in a position to return the suspect. But as long as you are in the country, as long as there are functional courts in Uganda, separation of powers, the Constitution would not permit the military to undertake judicial function. That's number one. In relation to civilians and our armed officers, men and women, no, because we agreed to be governed by a constitution. And to me, it's a question of basic or elementary common sense. Does Uganda run along constitutional lines? If you answer that question in the affirmative, we are bound by the decision of the Supreme Court that we cannot try people, whether civilians or otherwise, with criminal offenses in the courts martial. Courts martial are disciplinary tribunals for purposes of instilling discipline. If you have Kanyarugaba engaging in partisan politics, Kanyarugaba promoting sectarianism, promoting hate, threatening to kill, those are the people who would be disciplined there. But even then, and you know, even if you charged Muhoozi with a criminal offense in the military court, in the court martial, I would be the very first person to go and defend him and say, get him out of here. But if you are disciplining him for purposes of demoting him, removing a shilling from his salary, I would support you. But anything that leads to a custodial sentence is illegal. Now, what Parliament did is actually criminal to the extent that our colleagues, or maybe us, committed contempt of court. Court says, don't do this. Now, the other thing is when you look at clause 117A, capital A, which they introduced in lieu of 117, which was struck down, it is exactly the same wording as it was. After the court saying it is unconstitutional, you bring it back by force. Then there is the element of aiding and abetting. Still, that was canvassed by the Supreme Court. But
yeah, okay, you made very poignant observations. I wonder what Honorable Kwizera would want to respond to some of those things.
You see, when you are making a law, as the law has said, it is blind. You should not take it, make it looking at the personalities. So in this law or establishment of these court martials, you must, of course, use the Constitution. But what they see they were main addressing in this new law is the level of autonomy they are giving it to UPDF. The medical autonomy, insurance, a number of things, so decisions. But you remember we have one single treasury account, we have one government. So they needed now to have the administration, yes, but in reference to what Honorable Segona is saying, we look at trying of civilians. And now government, advised by Attorney General, saying that no, we can try this one by also making a subordinate court, that they will have the right to appeal. That one has been very, very critical. For you to say you are going to have a subordinate court, it means they will have a right of appeal. But those who have a right of appeal are described in the Constitution. So the Constitution, the Court of Appeal cannot receive all the cases from lower courts which are even outside those which are described or provided for. So it could have been maybe to also amend some provision of the Constitution to achieve the goal that they intended. Because we are talking about now maybe specialized courts. We have the land, the criminal, the what. So if they wanted the defense or the UPDF to have a subordinate court, they would not have only brought that the act itself, they would have also looked into, like, is it 134, 129, and say so that now there is no clash between the Act of Parliament and the Constitution.
Honorable Eddie Kwizera Wagahungu, Member of Parliament for Bukimbiri County, and Honorable Medad Segona, Member of Parliament for Busiro County East. Gentlemen, we're going to take a break, and on the spot, we'll be right back. Welcome back. You're watching On the Spot. My name is Patrick Amara. My guest tonight, I have Honorable Medad Segona, Member of Parliament for Busiro County East. I also have the Honorable Eddie Kwizera Wagahungu, Member of Parliament for Bukimbiri County. And we're discussing the passing of the UPDF Amendment Bill 2025, what will be its implication, and to the civilians. You know, I know there has been an addition that whoever is going to be on the bench of the court-martial must have some kind of a legal background, and whoever is going to be maybe the chairman must be at the level of a judge. But Honorable Kwizera, is considering that these are still serving military officers who are following orders, is it enough to have a legal background, but still you're a man or woman in uniform under the command? Does that separate them from taking orders? In case the commander has some political issues to score, has political scores to settle.
You see, when you are talking about dispensing justice and you are executive, because the army is executive, and the courts are not part of executive. That is the thing that must be harmonized. So who appoints? The courts, the judges, and the other judicial officers are appointed by, depending on what level, but with the president's approval. I mean, the president appoints, but Parliament approves. So in this case of the court martials, who appoints? And he who appoints, the one appointed by that person, is accountable to the other one. So that's where there is something which needs to be understood.
But even in civilian courts, at the end of the day, the president can appoint through the Judicial Service Commission, but these are not serving military officers. My worry
is the courts. There are enough laws, or even in the constitutional provisions, on the independence of the judiciary in the performance of their duty. They are not under command. So, but who appoints those who qualify to be?
So this is why I'm bringing this question to you. That there's a probability, Honorable Kwizera, that the court can be abused. You know, a political head or a senior military officer could be having scores to settle with anybody, and he will order a serving military officer who is the chairman of the court to do as he wishes.
Yeah, but
what will stop them?
You see, a standard is a standard, irrespective of who has said it, whether you are in opposition, whether you are not even in parliament. So when you are talking about appointment, and then who will investigate and prosecute, is very important. Those must be separated for fairness and justice. So there is still room, maybe for improvement. Maybe those ones who brought the legislation had not looked at that one, because you cannot investigate, prosecute, and even punish, or even judge.
But you passed it.
Yeah, passing it does not mean that it cannot be checked. It cannot be tested. That's why most of the laws, when they are not passed well, they are tested in the judiciary. I mean, the judicial test takes place.
Are you hopeful, Honorable Segona, that it can still be tested and it can still be improved? Even
Certainly not, because it's not improvable, it's incorrigible. The kind of establishment they put in place does not meet the test in Article 28 of the Constitution, where that every person in the determination of civil rights and obligations or any criminal charge, a person shall be entitled to a fair, speedy and public hearing before an independent and impartial court or tribunal established by law. Now, with respect to impartiality and independence, first of all, how can it be independent? The manner of appointment, as Honorable Kwizera said, is itself convoluted. One, the difference with the judiciary is that the president appoints people on recommendation of the Judicial Service Commission. Presumably, the president is not supposed to participate in proceedings leading to the appointment. His only duty, and I think that was the case of the Honorable Gerard Karuhanga versus Attorney General, his duty as president is to sign the instrument of appointment. Sometimes he's defiant, like, you know, he has contempt for every institution, for the Constitution, for everybody. But under the Constitution, he is not supposed to play a role. On the other hand, with respect to the court-martial, these people are supposed to be appointed by the High Command in consultation with the Judicial Service Commission. Now, whether the Judicial Service Commission approves or not, they have consulted you. There is no procedure or process for the Judicial Service Commission participating in the interviewing and recruitment process. That's point number one. Point number two, if you have an army like ours, which is largely political, where General Museveni says it is my army, the following day the son says it is my army, my soldiers. So it becomes a matter of inheritance amongst the Bachwezi. It cannot be independent. Then the other thing, remember when we were raising this in the Honorable Michael Kabazuguka case, we looked at two angles of independence, of competence. We looked at the technical competence. We also looked at the juridical competence. So the technical competence is like where you bring in lawyers, plus the non-lawyers who will at the end of the day vote whether they have understood or not. Now you go to the juridical, that you see, the Constitution separated roles, gave executive power to the executive, including its army. Indeed, in the Kabazuguka case, the Supreme Court decided that allowing the army to undertake a judicial function offends Article 209 of the Constitution on their functions. They have no judicial function. The Constitution is not amended, and is not amendable in that respect because it would be amended to defeat the import and impact of the judgment. So that cannot work. Now that you are preparing to sell your shoes, Eddie Kwizera, those shoes look like they are classified stores from the Schedule 7 which was given. Now for you, that suit looks like a classified
camouflage store. Green.
Yes, that camouflage green. You know, it's so bogus.
So in actual sense, what Honorable Segona is saying, this bill lacks clarity on, for example, what is military stores or not. I've seen your colleagues, I've not seen particularly you, but I suppose you must have been with them in some cases when you go to Chankwanzi and then they dress you in military uniforms and then you do military formation, you're in gumboots and told, some of you actually come back with your berets and your green military uniforms in your homes. So I'm sure you must be very careful.
At some point, our sister, the Honorable Lilian Aber, found herself in hot soup. I think she walked away with the uniform and wore it at some function. And there was, of course, there was a hullabaloo, except that she was a princess. Nobody would touch her.
Of which kingdom?
I don't know. Maybe the Bachwezi. Otherwise, if I had done that, I would find myself in the basement.
But seriously, these are very serious things you're talking about. I don't want to degenerate it, to get into the rabbit hole of tribal.
But please, if my statement is bogus, how about the statement made by the author who authored it, without a sense of shame and saying, Eddie Mutre is in my basement, we have removed his beard, he's in the basement learning Runyankore, meaning he was under torture. So, if it is bogus, it is bogus, we've got to say it. If you think it is embarrassing, why did somebody say it and he retained his office?
It is very embarrassing. It is very bad.
It's embarrassing.
This is the kind of thing that
I actually feel
it has no room and no space. By the way,
in a civilized society,
yes,
I actually feel
on this very show, it has no space.
I feel for my brother Genome Museveni, even if I were the one as a father, and that's the product you have. What do you do? The only problem is being so malicious and so bad to the country that is the product you want to hand the country to. You want to hand over the country to such a product. It's a problem.
I wish I could I wish I could use a rhetorical proverb, because it in English doesn't have it better. But perhaps you understand. Probably you could.
And I'll help you.
Bazaro Mubiri. Bazaro Mutima, you know, that you can produce a body.
I can help you translate it into Nyankore for people to understand it. Yeah, that's why I feel for him. By the way, okay. I urge everybody, don't talk about it scornfully. Do not laugh at the president. Do not laugh at his son. It's a problem. We have to go to deal with it as Ugandans and solve it together.
I saw the other day, I think a delegation of the European Union actually was having a conversation with General Salim Saleh. It looks like it has also, they haven't taken it lightly. But away from that, because...
He did promise to intervene. He said, yeah, you know, these are Gen Zs, educated. I mean, it's embarrassing as a parent.
That's education now?
Yeah, he will deal with it. He said they have masters. I don't know if our son Mhoz has a master's, but I don't know whether it's a master's in IT or a master's in insulting, a master's in threatening violence, a master in promoting sectarianism and tribalism. I don't know. But anyway, General Saleh was only dealing with, the Baganda call it binda chalacha, when things are very difficult for you to express. He was dealing with a problem. He said, we shall deal with our problem.
All right. I want to, we are digressing, by the way, and in some way.
No.
I want to get
that
back.
Is the person who generated the law and brought and sent it to us.
Oh, okay. If in that case, we are not digressing.
No.
So, Honorable Kwizera, you know, many people are worried, especially if you are in the opposition, that this law, if it is assented to, can actually be used to make life very hard for those who have different views from the NRM.
Not can, will be.
That divergent opinion in Uganda is going to be really squeezed to the extent that probably it will be non-existent.
Well, I think what I can read from the lawyers is that when you are making a law, they could be having strategic reasons why they are doing them. And in strategic thinking and planning, when you make disclosed and undisclosed objectives of the law, many people can use their own different ways to achieve their means, but law the way it is, since it cannot be made by the sector and be used by the sector, it can be challenged by Parliament.
But
and Parliament has followed its mandate.
Let me have this on record. You voted to pass it, right?
You say another thing which Ugandans should know, including our colleagues in opposition. This law was passed by Parliament. There is no individual member of Parliament who can distance himself from it. Because this is the law now that has been passed by Parliament, not some. It is collective.
So are you happy about this law? Are you contented? Do you think what you did a good job on Tuesday?
Yeah, but you see the issue that...
Are you confident that you did a good job on Tuesday?
The way Segona is saying, Honorable Segona is saying that he's not happy with about 2% of the law. Maybe I'm also happy with 90%. Because I had my views. My views may not have been heard.
Actually,
so everybody has...
Actually, everybody is happy with the 90%.
No, yeah, what I'm saying...
It is the other 2%.
What I want to tell you...
The 90 was supposed to accompany...
In a class. What I'm saying, in a class.
We vote on the clause by clause.
In a class, people don't perform the same way.
Yeah, but our focus,
in this making of the law...
Our focus is on the clause of the military court.
What I'm saying,
trying civilians in the military court.
In the making of this
What was
law,
your stand in this debate?
In the making of this law.
Honorable Kwizera, civilian being tried in the military court, what was your stand in this debate?
The stand of Parliament is my stand. Because this law has been passed by Parliament.
You know you go clause by clause.
Yes, you go clause by clause.
And clause by clause you give your views.
But I'm saying this law...
You give your views,
Mr. Honorable Kamara. This law has been passed by Parliament. I am a member of Parliament.
I know. Before you even go for the collective responsibility,
even in the cabinet,
for which the people
even in the cabinet, when they disagree, they don't come out to say.
But that, by the way, cabinet has a special rule on that. We are not bound by that by that collective responsibility. For cabinet, it is in the constitution. They are bound. I am not bound. I actually disassociate myself from those acrimonious clauses. It pays to do good. It pays to do the right thing. Because it offloads you. I mean, it takes away the weight of explaining.
Because you see, the hope either way is not lost. Because this law had been there until Kabazguruka challenged.
Yes.
So, meaning that at any level...
And you passed it in 2005, you were there.
I was not there in 2005. Now, after 2000, now this 10 years, it is going back at court. Maybe another 10 years again, 2030, so, I mean 35, maybe it will come again. So, but this is a lesson. At any level, government must learn and individuals must learn.
So, Honorable Segona, I've seen your colleagues, not really colleagues, but party members, sometimes behaving in a manner that could be understood to look like military, military formations, military style beret, military style kind of things, even if it is not UPDF. What is that supposed to imply?
That I look like a criminal, so I'm a criminal. You see, how have they behaved in a manner that looks like military? And is it offensive to the laws of Uganda that when I'm engaged in a formation, people do so many things, even those that you feel by your common sense that you wouldn't have done them. But it's not prohibited by law. So you want to say that this law was targeting them? Why would it target them? If I put on a beret, that beret does not belong to the UPDF. The UPDF's beret has an insignia that distinguishes it from other ordinary caps. So it is nonsensical for somebody to say, oh, because they made a military-like formation by lining up. How many times have we done it, even in school? How many times have the scouts done it? It's simply targeting political dissent. So nobody will sensibly tell me that that is the reason it has come. No, the reason is it has come, I think Honorable Kwizera mentioned it, that that political temperatures have started going up. And to some people, when the political temperatures start going up, the reasoning goes down. Okay? That's number one. Number two, I live in a society, and I come from a family and a clan where people really age. We, dying at 98, My grandfather died at 98.
Actually, our life expectancy in Uganda is just 66.
Yeah, but
so whoever is above 66,
I am talking about 98.
Yeah.
My grandfather exceeding it by 33 years. People learn to become petty. Just like children, something small will annoy him, and so on and so forth. So I think we are descending into that pettiness, that, oh, someone has put on a beret, it's like having like a UPDF. It is actually called schizophrenia in psychiatry, where somebody looks at you and imagines, oh, this one is about to attack. Then the next thing you hold a knife and you want to pierce your wife. That's where we have descended. I think General Museveni, given age now, is feeling insecure. Okay? Anything that he thinks threatens his hold on to power. And he thinks anything can get him off power. First of all, he's not popular. Secondly, he's aging. Thirdly, because physically he's getting weaker. Now he thinks people really take him for granted. So he's got to bite and bring out his entire might. All the energies that he thinks he's been collecting over the last 86 years, he feels now he must use it to hit and crush them.
He's 86 now?
It should be about 86. It is an honorable thing. You people take it as if it's demeaning. It's an honorable thing to age. But I want him to age gracefully. How old is he?
Well, I don't know.
By your information.
He himself was estimating the time he was, I think, I think in his book, Sowing the Mustard Seed, he doesn't say exactly when.
It doesn't matter. He doesn't know.
He gives a rough estimation.
He doesn't know. We are helping him now.
He gives a rough estimation of when he thinks he was born.
Since it is rough, it is not arithmetical. Yeah. I'm also looking at him and compare him with my relatives who are 86. They look like him.
Honorable Kwizera, I wonder how the military will be able, to deal with these issues in case somebody is brought before them. I want to give an example of somebody who was accused of committing heinous crimes against humanity, terror, abduction, taking child soldiers into the bush and teaching them to fight, and harassing Congolese, Ugandans, and other people. Captured in Tanzania or arrested in Tanzania, and is facing international division of a court, but it's a civilian court. And I'm talking about a gentleman called Jamil Mukulu, who's none of the people here.
Would you include the word who is said to have done those
That's what I'm saying. I'm facing allegations of all these things. Having said, he's facing very serious allegations that you cannot, even not comparable to any Ugandan can face. But civilian courts are handling. And he's there fighting for his...
You see, when we talk of a government is... it has a number of components, and so there are a number of departments, agencies, but they are all intended to serve the common person. So even these roles which we put there, they are supposed to be actually as fair as possible, because the Constitution is supreme, and they say we draw our authority from the people. So when you look at Jamil Mukulu you're talking about, I think the arrows they are using to try him, because he has not disputed about either he wants to go to martial now or to go either side. So I think now there has been, and the law must address a gap that is existing in society. And that there must have been sufficient studies, but you must also have capacity to conduct that study to fill the gap. So if we have some people who have been using arms to terrorize people, Others are charged under the terrorists, international division, maybe terrorism. And then you find that there are other people who are also charged in a different court. I think that one becomes also unconstitutional because it is discrimination. I don't know if they're gonna. You are right.
Yes, and
that court it was the constitution.
It was decided in the Kawazugruka case.
Yes, well. That is a matter
discrimination
that was settled in court. I mean, that was settled. So in this case, I want to disagree with my colleague Segona that the president maybe is old.
Sorry, he's young.
No, he's not young, but you see, the president has a person and a system. Systems are, they call the systems. You have ministers by constitution. They are supposed to advise the president.
As far as I'm concerned, in 2012, he spoke in very clear terms about when somebody is 75 on whether you're actually strong enough to handle. And I'm inclined to believe him because he understands the pressure that comes with the job. And he said he wouldn't because it is scientific, biological, and it was absolutely very clear. I don't know after that.
Of course,
he's never spoken more clarity.
As I tell you, at different situations, when you are faced with a situation, you take a decision. And that decision might be tested. Yeah? And the results might be different.
But you might take a decision with diminished ability.
so, what I'm now saying, where should Ugandans get worried? Like the way...
I'm surprised if they are not worried already.
So now, we have ministers who are supposed to advise the president. Are they doing their work?
No, he's advising them instead.
So, if you are a minister, you must have capacity to advise the president. But for a case of Uganda, which even me personally waited for the constitutional review to change that thing where where members of parliament who are not doing what can be recorded, the constitutional provides for it. Recalling a member of parliament who has not performed in expectation or to expectation of the people who elected him. That law, because of selfish interests, members of parliament have not touched it. And I'm being honest. Secondly, ministers are supposed to be full-time to perform the work, national duty. And members of parliament are also full-time. So in Uganda, we have ministers who are actually constituency ministers. I would think who even don't have time to advise the president. Whether the president creates an environment to be advised is another matter, I don't know. So is it that they have not advised him where there are some errors? No.
Well, or that he's not advisable.
If the words of the current Inspector General of Government are anything to go by, the Honorable Betty Kamya is quoted to have said that he's actually can think better than 80 members of cabinet. He's good to go alone because
that the president can think for 80 members of.
Yeah, he said something.
Actually better
than them.
But that was a personal opinion.
Yes, it was. He was a member of cabinet.
No, but it depends on the ministers he appoints.
But you see, what's interesting that Kamya was a minister.
Yeah, and
so she didn't have capacity to advise.
Yeah, she was confirming what she was saying.
So that you needed 80 Kamyas to get 107.
But okay, we agree that so the president needs to be advised correctly, by the way, and efficiently, in accordance with the law. But as to whether he's advised is a matter that
and whether he's advisable.
And whether who advises who is another matter.
So, so Honorable Segona,
yes,
I can talk with certainty that your colleagues or yourselves will go to court over this.
I already have instructions.
Okay.
Yeah, because, I mean, let's try. We are not going to fold our hands and say, oh my God, they have the numbers, etc. No. Of course, they have the numbers, we don't have them. we will defeat them using what we have. It is the power of intellect. It is the power of the law. And I mean, I'm yet to see what their defense will be.
That power of intellect didn't work on Tuesday.
No, it works elsewhere. It doesn't work in every situation. Actually, it is the power of intellect that allowed us not to participate and wait for the next level.
You know, Michael Kabaseguruka went to court. It took almost 9 years. So in the meantime,
yes.
in the meantime, the law will be applying as a. If that is the record to go by, then you can get the reprieve maybe in 2035.
We shall cross the bridge when
but
we
you see, Honorable Kamara and colleague Segona, one of the reasons, or the more.
Was he being prosecuted?
One of the motivations of the court martials, if I need to be corrected, that they are more efficient and they are faster. That's what they say.
They're efficient because they are doing junk.
No, that's what. No, what I'm saying is that.
If efficiency means speed.
No, what I'm saying is that what stops other courts from being faster?
Okay, that's a good.
That is the what should be cut.
First of all, it is also a wrong thing to say that they are efficient, that they are faster. When was Kale Kayihura charged? How many years ago?
He was there for about 2-3 years.
When was General Tinyefunza charged? Longer before. Have their cases been concluded? No. Secondly, you are saying they are efficient to you if efficiency means speed. One, look at their numbers. Number two, look at the quality of work they do. You would enter the court martial and the chairman would come with a new file folder and new foolscaps, blank papers, every time you go to court. There is no record. Okay? He would read today a ruling and which is written for him, read it with difficulty, and that's it. Number three, you're talking about that efficiency because which affects quality. We will say that justice delayed is justice denied. But equally, justice hurried is justice buried. A colleague from Karamoja was telling me the murder of Father Declan Ture, some Irish name of sorts, that priest who was killed. And they slaughtered 2 young men. The person who actually killed him, this colleague was telling me, a colleague from Karamoja told me, one day I visited Fort Portal, I found the man who actually shot and killed the priest, who is a captain. But these people were already killed. They were not even afforded the due process of the law. Because the Constitution requires you cannot execute somebody without confirmation of the highest court. But this was a field court martial, as if they were at war. Within 1 hour, they had been executed. So that's what we call efficiency.
And they find the person who killed is alive.
And I was surprised when it came to voting that this person voted for this law. Let me tell you, it's a bad law. Number two, it's a bad institution that you're giving a wrong job. UPDF is good when it comes to defending us. UPDF is very bad when it comes to deciding cases because that is not its job. So, what causes backlog? Now, speaking as a lawyer, I know a thing or two, quite a number of things. If you look at criminal cases, for example, you find the police or the army now participating, rounding up people without evidence. They have no case against you. They say, let's just get him. One day, when they kidnapped us, myself and Honorable Nambos and the Katikiro in 2008.
They brought some of you in my home district of Kenjojo.
Of Kenjojo, yes. I was kidnapped on Friday. kept on till Sunday. The Honorable Kwago and Honorable Kaddo Mukasa came to see me, even Honorable Betty Kamia. And when they asked Charles Kataratambi, what is the offense? He said, oh, they've not told you. I said, I've not been told my offense. He said, Semeo will issue a press release tomorrow on Monday. Imagine, the person in custody doesn't know. His next of kin doesn't know. His lawyer doesn't know what the charge is. Semeo, the spokesperson, would issue a press release on Monday informing the nation. First, I would not attend that press release. I mean that press conference. I would not access the newspaper. So I asked now, okay, after him issuing that press release, when will I know?
But you're supposed to know
the offense
on the time of arrest.
That's the point I'm making, because I understand when they were giving orders to arrest, somebody said, Afande, we arrest and say what? Said, no, you first arrest, I'll tell you what to say. So, you arrest people, you have no cases against them. Actually, at that time he was forced to tell us that the holding charge is inciting violence, which eventually I was never charged with. So, politically trumped up charges contribute, I believe, about 30% of the backlogs.
Okay.
Number two, people who take matters to court to get an injunction and enjoy the status quo. Number three, until recently we did not have enough judicial officers. I want to believe that now, with the new recruitments, we will be better and we will do better. Of course, the problem is that they come in and find a backlog. Number four is lawyers in Uganda are not paid to the scale. Because of that, I think they end up holding on to too many cases.
Okay.
Yes, but also you may drive to Fort Portal and they tell you the judge is attending a conference in Kampala when the judge is the one who fixed the matter. I think some of those administrative issues have generally, incrementally being sorted, that now the judiciary communicates, they inform people when the judicial officer is not there, but that doesn't take away the question of backlog.
You know,
So,
Honorable Kuzera,
but of course, they also the poor facilitation.
in this bill, if it turns into law, I understand that if a military officer is accused of maybe doing something that is subversive, and perhaps they say he was in cohorts with the Kwizera, and even if you are a priest, they will bring you to the military court martial, just because somebody has alleged that you were together.
But in dispensing justice, there must be standards. And those standards cannot be, say, for one section of society. It must be, uniformity must be there. So you cannot say, I would expect justice more when I'm tried here or here. So the fairness and the dispensing justice must be standard. To the extent that government should not find it better to dispense justice in
the military.
In the military than what it's supposed to do in the
Civil courts.
In the civil courts. Because actually one time the president said, can't we audit some judgments? And there he was, I think I supported him, because there are some judgments you find that they show short of the expectations. So even here in investigating cases, whether civil, military, or criminal, do we have a system to audit those cases to see if they are investigated in accordance with the set standard? So this one can apply even in the military. even the police. So you have cases which are investigated. The Honorable Segona, you recall when the Human Rights Committee went to Rosera, and they found we can't, with the suspect or what, has been there for more than 20 years without going to court. So who does that audit? Who checks? So if there is a standard, who is investigating, how many years does it take? Like now we have a Constitutional Court. Constitutional Court, Article 137, they say it must be expeditious, it must take precedence, but you find some constitutional matters have gone to court and are there for about 10 years. So, what is the problem?
Have you forgotten there's a time you spent without a Chief Justice?
So,
in this country.
So, where is the problem? Who has not done his work? So, I think that whatever happens, people must learn from bad things and good things for better. You cannot have a case for 10 years and the president says, no. These cases take long in civilian courts. So you as personally responsible for civilian courts, you must know that the president already has given you a vote of no confidence. Why should the president praise court marshals and
because he uses them
vote of confidence? I mean,
he uses them for politics.
But why can't these civil courts also work faster?
I have given you the reasons for a long time. You remember how we were pressing government to increase the number of judges? You remember?
Yes.
Where we passed resolution after resolution, etc. Kamara, let's be fair to these people. A year has 165 days, 52 of which are weekends, which is 104. Now, you expect a judge to conclude 300 cases. It is impossible in a year. No. It is impossible. Of course, some of them have also been lazy. I mean, you reserve a ruling on an injunction, and you say, come back after 2 weeks. Some actually, even after a month, they don't give you a ruling. There is a level of also of laziness which has been. But then
isn't it provided that after concluding the matter, there is a time limit when they can give a ruling?
No.
Is it 60 days?
No. That used to work with election matters.
No, election matters, but even
not ordinarily.
You mean you can conclude the matter?
But you see,
and it takes about 5 years for judgment.
Even yes, it is possible. Even those even if you go by a standard of 60 days, on a daily, they keep allocating you more and more cases. So really, we would plead for these judges back then, before they increased the numbers. It was pathetic.
But now that they have numbers,
I think they have to deal with the backlog.
In the interest of time, we want to make our concluding submissions on this issue tonight. Let me begin with you, Honorable Medad Segona, your concluding remark.
Well, I can only say, Ugandans, this is our country. We have no second home. We must keep trying. We must fight from all fronts. The law was brought in bad faith. Those who brought this law really hate Uganda. They hate us. They destroy institutions. The judiciary, especially the civil courts, may not be the most perfect. Do we have a perfect parliament? Do we have a perfect executive? Are we going to take away all the powers and hand them over to the military because civilians have disappointed us here and there? The answer is no. We've got to choose whether we want to be governed by a constitution or we want jungle law with these people who came from the bush and the bush refused to go. If we want to be governed chaotically, let's meet at the city square and agree that we want to be governed chaotically. But if we do not want to be governed chaotically, let us stick to the Constitution. Let us respect these institutions. I was in Ntinda, when we were praying for the late Joan Kagezi, and General Kale Kaihura said that we should remove the 48 hours rule from the Constitution because they need 90 days to investigate. Chief Justice Emeritus Bart Katurebe came and reminded him of that book. Is it Man of All Seasons? Said, don't cut down that forest. You will need it when they're chasing you. So, with all our imperfection as Parliament, don't destroy that Parliament. That's number one. With all that you perceive as imperfection of the judiciary, don't destroy that judiciary because you will need it. If you remember how many times people bashed Chief Justice Owindolo, okay, a time came when he delivered a judgment that we are praising the judiciary for. So, because someone has disagreed with you today, don't admonish that person. Don't kill the judiciary. We need it.
Thank you very much. Honorable Kwizera, your concluding remark.
Thank you very much. And I want to say that we have a parliament. A good parliament is good for the country, the president, the executive. A good parliament is good for the country. So when you demonize the parliament, you are actually demonizing your country. Judiciary the same. So what is expected is that all of them must perform in accordance with the law that established them, and they must do it independently. But when some of them decide to surrender their roles and mandates, it falls short of expectations. And when it falls short of expectations, I want to appeal to Ugandans that you are not judged only by, like especially for voters, you are not only judged, Parliament is not judged only by the voters or Ugandans. It is even judged internationally. That's why we belong to many international organizations. Executive is also judged because when there are people investing here with loans, they say, hey, what's the level of the political risk? What's the level of the judicial risk? What is the level of the parliamentary risk?
If you permit me, Eddie, actually even the voters, when you are voting people into Parliament, please send us people who are up to the task. Don't just pick people around.
So this is what I wanted to say, that the issue, things must change. So the issue of having members of Parliament, tomorrow they become ministers and you find there's a conflict of interest. It is the nature of the president that when you are appointed a minister, actually you resign. So that there is clear separation of mandates and powers, and there's no conflict of interest for the system to be better. So I would think that the president has learned from good and bad things that have been happening. So we believe that the systems will be better because I believe in system improvement.
All right, I want to thank you so much, Honorable Eddie Kwizera Wagahungu, Member of Parliament for Bukimbiri County. Thank you so much. Honorable Medad Segona, Member of Parliament for Busiro County East. I want to thank you. And more importantly, you, the viewer, I want to thank you for the privilege of your company. I know Uganda, we are good people and we have a good country. Sometimes we disagree and sometimes we argue, but that's the nature of debate. But as we argue and disagree, let us remember not to destroy our country. We have choices to make, to develop or to destroy. I beg you, Ugandans, let's choose to develop. Good night and God bless Uganda.